Okay, good evening, everybody. This is Kelsey signing in from Chicago for another session of Black Community Unity, Thanksgiving week. And I want to, first of all, give a shout out to my co host who is not here this evening, Reverend Elliot Parker. Has family coming in this week for Thanksgiving, and so we gave him a night off. But I told him I would give a shout out to him. Rev, I hope everything is okay at home. If you're, hope your relatives, if some came in today, arrived safe and sound. Hope you have a great holiday. Also, we want to give a shout out, as always, to Myron Otley and the Metro Singers for giving us our theme song, Still Away. You can listen to the total rendition of that song by typing in on the search engine of your computer, Metro Singers YouTube Steal Away. And that selection and other selections will provide you with their singing. They're a great group. They're out of Hyattsville, Maryland. And want to also, as always, commend Earl Winfrey, our producer, and Wanda B, for making all of this possible for us, providing us with a forum where we can come and inform you of whatever it is that we want to talk about. And also, we want to give a big shout out to all of the intellectual radio family. We want everybody to have a nice, safe, joyous, and tasty holiday. Okay, we're going to get right into what we have to talk about today, this evening, November 20th. Over the weekend, I was moved to really ponder the idea of running for elective office. And the reason being, and I prepared a statement. What I'm going to do, rather than just talk ad lib, I'm going to read the prepared statement that I wrote. Over the last few years and beyond, much time, work, and some expense has gone into helping others at times when perhaps there was not much room even to help myself. That being said, and moving forward, and most recently, the endeavors of this podcast, this internet radio show, has reported to you within the last few weeks our work in proffering a new and innovative concept, a boomerang concept or reversion consumerism in regards to the vast amount of dollars that is spent on children and young adult clothing. The concept has roots that are bearing other conceptual fruits like reversion consumerism and stand the possibility of setting American society on a new and never before pursued course while creating a new map for educational, economic, and social engineering. I have elected to seriously consider a run for elective office, which to date I am at this moment uncertain. My decision to consider public office is not rooted in any selfish ambition, as I have worked and traveled at my own time and expense over the years and have never sought any accolades or special notoriety. I have pleaded for funding on behalf of others, not associated with my own community at times, nor my own race, on many occasions. Most recently, the work that has been offered has drawn much moral support and encouragement. It is because of the great potential of this work that I feel the best way to dramatize and highlight its endorsement or non-endorsement is to place the work beyond the walls of the many churches that I have called, informing them of this work, and further the solitary ears of those whom I have requested opinion on this matter, and place the work into a public forum where endorsement of ideas are beneficial to the growth of the community, city, state, and national interests, and often find a place on the ballot. And the person to whom the inspiration was given a home where our country's politicians have been placed by decisions of those courted for their elective franchise. To do less than expose the work that we have offered and begin the process of making it public on a much more serious scale is to allow our shared vision of a safer, better educated, and revenue supported future for our children to face the discouraging sentence of initial interest followed by a gradual, slow death and disregard. So we need to put it in a public forum where it can really get the attention that it deserves, is really what I'm saying, or else it will dissipate. The initial interest will dissipate and die, and that'll be the end of it. Thus, the winning or losing of elected office for us is not totalis damnum or a total loss. The mere exposure of the candidate for public office warrants the attention of the public, for out of this category of public hopefuls have emerged historic figures in our nation's history whose ideals, rhetoric, their vision and aspirations somehow connected and meshed with the majority of those persons who saw them as the best or less than worst of those seeking that elective endorsement in office. This is not running for office is not the first time uh, that thought has come to me. When I lived in Alaska, Anchorage, Alaska, several years ago, I did a lot of these same type of much of the same work that I'm doing now, always advocating on behalf of others. And that running for office was mentioned to me by several people. Had I thought about running for office then and so forth, but of course I didn't think I was going to be living in Alaska too long. So I really just thanked them for the comment, the suggestion, and just went on ahead and did something else. Running for elective office carries with it risks, to be sure, particularly the examination of one's character in particular. In my case, I would have to overcome the burden of explaining away a murder conviction to which I pleaded not guilty, refused a 7-year plea bargain, and lost a trial and was sentenced to the Illinois Department of Corrections in December of 1989, and for which I served nearly 13 years in prison. This unjust conviction has placed upon me irreparable harm in terms of personal associations, particularly in regards to employment. As has happened in other cases, I was just released from being hired not long ago, undergoing job training, and then released upon their learning of the murder conviction. Once my background check came back, I can think of several instances where that has happened. The trial of People versus Wicks, that's me, did not include persons who, if called to trial, would have caused the standard of reasonable doubt of my guilt to rise to a level that would not have allowed the conviction. Key witnesses were never called to the witness stand. One witness hung with me 3 days during a very, very cold period in Chicago. I believe I was convicted December 21st, 1989, and that was a few days before Christmas. And it was bitter cold in Chicago. And this man knew how to fix broken pipes and so forth, and his phone was ringing off the hook, but he stayed with me. He said, "Man, this is really serious. I got money coming in from all sides, but I'm going to hang with you." He never hit the witness stand. Had crucial testimony regarding my innocence. My case then was rendered to the telling of the story of the Christmas Carol, absent Ebenezer Scrooge, Bob Cratchit, and Tiny Tim. Christmas story by leaving out those three figures. Well, that's what happened in my case. The key people who would have testified, and I do believe I would have been vindicated, because the standard in a criminal trial, as you know, is proof beyond a reasonable doubt, and they wouldn't have had that. On several occasions, I've put forth, in regards to my character and in regards to this conviction, just this year, when this conviction pops up, I take no prisoners. I do what I have to do. On several occasions, I have put forth the challenge on my website and made it known to let's fill a forum with 100 pastors or spectators from the public, the investigative team or persons from the media, the news media, and the state's attorney's office, and let's discuss the case of People versus Wicks in Illinois. And I ask that same standard be done as I speak to you this moment. We can do that anytime that you want to. We can get a room full of pastors and spectators, the news medias, people that I know who still know something about this case. They're still around, and the state's attorney's office, and let's discuss this case. Untrue allegations surrounding a person's acts and or character are damning. And in some cases, the only way to shed the malignant perception created by such words is to place the persons in a setting where words matter criminally or civilly in order to ferret out the truth, untruth, motivations, misconceptions, and errors. But the heralds of my inability, in many cases, to find employment only mirrors the experiences of so many other previously incarcerated persons. It begs the question of whether the employment practices of our nation squares with the ideals found in the preamble of the United States Constitution, which is the foundation for the United States Constitution. For from the preamble grows the fruits, which can be found in the articles and amendments that comprise the words of this great document. But the foundation is the preamble, and it begins, we the people, in order to form a more perfect union. Perfect union how? By excluding some Americans from having access to a higher, safer, better paying job, and so serious an exclusion as the means by which one will pursue the ideals of life, liberty, and the pursuit of happiness. We're not just talking about being able to use the same laundromat as someone else. We're talking about having the same privilege and the same opportunity of accessing better paying, safer jobs that can afford a person a better lifestyle, that can afford a family a better and higher standard of living. If I had children and a wife, for example. So my experience in terms of battling this unjust conviction and trying to land good paying jobs, had good paying jobs, decent jobs, been released on them once the background check comes back. The preamble of the United States goes on to say, to establish justice, meaning fairness. But how? With discrimination in hiring practices towards previously incarcerated persons is or should be an aberration of the civil rights of Americans. There is nothing fair or just in the policies of businesses who refuse to hire United States citizens who belong to a class of previously incarcerated individuals. The preamble goes on to read, to ensure the domestic tranquility. But how? By closing the door and opportunity and making it difficult to provide for one's family or for themselves, thus making them vulnerable to the enticements of the street, luring them into vices or immoral behaviors just to survive. which in the black community has gone on far too long, or to continue to use previously incarcerated persons uh, because of their lack of being able to find gainful employment, return to the penitentiary system, the penal system, as human fodder, and to provide fuel for the nation's prison industrial complex, hindering us, black people, from, as in other races, from relying on the content of our intellectual and moral force and fullness of what we have to offer society, such as entering the more respectable professions of medicine, law, academics, and business acumen. And although we have many black people in those fields, we could have more. The preamble goes on to read, to promote the general welfare. But how? The word general means universal and includes all parts or aspects that should incorporate previously incarcerated persons into the job workforce. If it's to promote the general welfare, that means everybody, general, universal. Hiring policies of some businesses in the United States, when they will not hire previously incarcerated persons, in light of all of the evidence that false and unjust convictions are commonplace in the United States, almost to the point of humiliation. Times how DNA results come back and people are released from incarceration. You've seen it many, many times. You've seen the movie Reuben Hurricane Carter, played by Denzel Washington. Confessions extracted during interrogations by placing electrical shocks on the testicles of men. The many people exonerated by DNA testing. The helpful groups like the Innocent Projects who have labored tirelessly trying to free unjustly and wrongly convicted persons. You've seen all of that. The point being that no one can tell in many cases if a person, though convicted of a felony, is truly guilty or truly innocent. Thus, to maintain a blind system of hiring that excludes those having been convicted of felonies is not in any sense justice, that is fairness, nor does it promote the general welfare, nor the universal well-being of all citizens involved. All businesses in the United States who place their products and services on the common market likewise depends upon the federal government to help them keep them solvent. All businesses in the United States who place their products and services on the common market likewise depends upon the federal government to help keep them solvent or in business. How so? This dependency is found in the legal tender or money, coins minted in the United States Treasury, or currency or dollars that are printed. Those are federal objects printed by the federal government. And businesses in the United States have to use that means of legal tender in some form. If a business accepts legal tender from a previously incarcerated person, yet refuses them entry into their workplace, is exhibiting business conduct that can be construed by many to be constitutionally, the preamble, remember I just read it, to be construed by many to be constitutionally immoral and unacceptable, and creates a conflict. And conflict is spelled capital C, capital O, capital N, capital F, capital L, capital I, capital C, T. Creates a conflict with some of the wording found in the preamble of the United States Constitution, and perhaps conflicts with the equal protection clause, found in the 14th Amendment of the United States Constitution. The United States Supreme Court is very open to hear cases that conflict, such as state law versus federal law. Something may be going down in a specific state or a city that might conflict with the United States Constitution. And the United States Supreme Court wants to hear that. There may be a conflict with companies who, for whatever reason, whose hiring practices do not allow entry into their workplace for previously incarcerated persons, and yet they are using legal tender, the money created by the federal government, to keep their business solid and solvent. There may be a problem there. Dollars spent by the previously incarcerated finds its way into federal coffers that regulates the airwaves for radio, television, cable, etc., which allows business to make sales and expand their clientele base. Excuse me. My dollars, previously incarcerated. Dollars spent by previously incarcerated persons finds its way into the coffers for street and railroad track repair and maintenance, and allows trains and trucks to deliver goods, and provides the transport of many employees to and from work, to businesses, some of the businesses that will not hire me. And yet my dollars somehow indirectly find its way into the coffers for the streets and the railroads and the trucks that brings them their products and or services. Conflict. Dollars spent by the previously incarcerated into the city provides for running water to drink and for sewer purposes. Dollars spent by the previously incarcerated finds their way into federal coffers that funds the necessary agencies that regulates interstate travel of planes, buses, and trains, which are so integral to the comprehensive well-being of business and the general populace of the American people. Is there some evidence, some precedent that the foregoing reasons to drop hiring barriers to persons previously incarcerated has not fallen on deaf ears for some entities? Have there been some moral stirrings or persuasions on this issue? Yes. The city of Chicago and the state of Illinois does not ask the question of previous criminal background when filing for an employment application with them. That is the city of Chicago and the state of Illinois. So there has been some moral persuasions that have occurred that would make the city of Chicago and the state of Illinois decide against having that question asked when filling out an application for them. The right to work at any business in the United States which uses federal legal tender, coins, and money in some aspect, whether it's currency or whether it's some type of money wired or whatever the case may be, however they decide to move it. The right to work at any business in the United States which uses federal legal tender as a way of meeting financial business requirements should be a constitutional right for previously incarcerated persons. What I'm saying is that if any company uses money in any form, money from the United States government, the federal government, the United States Treasury, They should allow access to the workplace for previously incarcerated persons. The right to apply for a position at a business or anywhere unencumbered by any previous criminal background, real or falsely accused, is as much a constitutional right, should be as much a constitutional right as is the right to vote. Anything less is a violation of one's civil rights. Even in the landmark case of Plessy versus Ferguson, whereby the separate but equal doctrine was established for segregation. The phone rang, so I'm just going to start over. Even in the landmark case of Plessy versus Ferguson, whereby the separate but equal doctrine was established for segregation between the races in regards to public facilities, the reality or equal, the reality of the separate but equal doctrine was that it was not equal. Black people suffered their facilities and schools and so forth were not equal to that of the rest of the country. It fell way short. But the point being, the language that held the separate but equal doctrine created one part of the equation was equal. Brown versus the Board of Education, which overturned the separate but equal doctrine. It didn't overturn Plessy. It overturned the separate but equal doctrine. Brown versus the Board of Education, whereby the court ruled that the segregation in public schools is inherently unequal. You know the famous case. It did not overturn Plessy, but it overturned the separate but equal doctrine. But the employment interest of the previously incarcerated persons falls lower than the separate but equal standard set forth in Plessy. Because don't forget, the equation was separate but equal. In our case, in the case of the previously incarcerated who don't have access, and that was the issue with Plessy, was access. One of the main issues was access. The reality that previously incarcerated persons experience is a standard lower than Plessy, because in Plessy it said separate but equal. But me coming through the door of a business applying for a position, I fall lower than equal because I can't even get in to apply. Or if I do apply, okay, once a background check comes back, or if I check the box, my application is not going to be given any weight. So there's no equality. There's no fairness. There's no promotion of the general welfare. There is no justice in the experiences of the previously employed when they don't have access, fair access, universal access to better wages, safer employment, as do persons without a criminal background, whether it be just or justly accused or convicted, or unjustly accused, notwithstanding. Lastly, I just wanted to say, so in order for that to stand, to be universally accepted, what I consider to be a violation of one's civil rights just as much as it would be the right to deny me the right to vote. Companies who don't allow access to their workplace, who would not hire me as an employee, would have to be 100% sure all the time that by denying previously incarcerated work due to their criminal background records, that they would be sure. And that they cannot do because the evidence, Reuben Hurricane Carter, the extracting of confessions from people out on the south side of Chicago by hooking up their testicles to uh, uh, electrical impulses and so forth. The fine work done by the Innocence Project. There's no guarantee. It would be easy if someone came into your uh, business and sat down, and every time they sat down, a purple light would come on if they were guilty, or an orange light would come on if they were innocent. But it don't work like that. You have no way of knowing when a person is truly innocent or truly guilty, thereby not allowing access into your workplace. I think is an aberration of a person's civil rights. Lastly, I also indicated on the accompanying website that we have, we-go.net, that I was going to speak on a symbol that we have for our K1, K12 uh, clothing inheritance. And the symbol is going to be a some sort of a trust, an inter vivus trust, or some type of a will, only symbolic in nature. It's not going to have any legal weight or ramifications to it, but it's a symbolic gesture that we're handing down uh, an inheritance to our children, a model and a blueprint, some type of a document. And you know how big I am on documents. Always have something down on paper. An inter vivus trust, a living trust. Vivo, the word trust, live, that we can hand down. An inter vivus trust is a fiduciary relationship used in estate planning created during the lifetime of the trustor, who would be the adults, all of us, passing down to our children. Also known as a living trust. This trust has a duration that is determined at the trust's creation and can entail the distribution of assets to the beneficiary during or after the trustor's uh, life ends and so forth. So we want to do that. And also to tell you a little bit about myself, I'm not just asking to uh, run for office, just impromptuatively, I guess the word you could say. But also I have here, I've been doing what I've been doing for quite a while now. I can go back to the and I actually remember writing an article about an inter vivus trust, why a person might consider putting their assets into an inter vivus trust, a living trust, probably about 1983, in a friend of mine's newspaper. And also, here's a uh, article that I wrote in 1994, which was published in the Jerusalem Chronicle out of Memphis, entitled "A Proposal for Self-Reliance for Public Housing Residents." And basically, what that article comprised of was uh, putting forth the idea that public housing residents, the big projects, the Robert Taylor homes, the Cabrini Greens in Chicago, Illinois, that people stop taking their money across the street and giving it to people who really did not have. In other words, going to the store across the street, did not have their interest, had a stake, had a interest in upgrading or enhancing the community. But rather, I suggested that all of those projects in public housing back then have their own in-house commissaries where they could buy their own groceries. Uh, for example, the article says it is estimated there are close to 200,000 Chicago Authority residents grocery and commissary facilities owned and operated by CHA residents that can yield a 10% profit margin could generate revenue that could create business ventures, provide educational trust funds for public housing youth, and provide job skill training and so forth. Okay, and I got this reading a book by Alex Kotlowitz entitled There Are No Children Here. Oprah Winfrey played in that movie. I think she played LaJoe Rivers. And in that book, it indicated that LaJoe Rivers spent $542 in 1 month to feed a family of 13. And if there's 200,000 persons in the Chicago, at that time, 200,000 persons in the Chicago Housing Authority, public housing, I imagine you could imagine how much money they would spend in 1 month, and definitely how much money that would have been realized in 1 year. And if there are public housing residents, I don't know, I haven't really looked it up, in other parts of the country, you might want to consider that, having your own in-house commissaries. And lastly, I'm going to share with you a book that I found in the Chicago Public Library. They was, you know how they getting ready to get, they give away books, try to get rid of them. And so I bought this book for $1, and it's, I'll let you see the cover. It's an old picture, circa probably well before the 1900s. The book is titled The Education of Blacks in the South, 1860 to 1935. And of course, you know, we've really been pitching that we want to create the desire to learn for our high schoolers because of the disproportionate number of Black boys that are graduating from high school nationwide. It's not on par with their counterparts. And so we want to find a way to create this commitment and desire to learn for our Black, for all students. But because of this lag in the graduation rates for Black boys, we want to definitely focus on them too. But I just want to share with you a chart on page 188 of the book. The Education of Blacks in the South, 1860 to 1935 by James D. Anderson. And the chart shows high school enrollment by age, race, and the southern states in 1890. And the states listed are Alabama, Arkansas, Delaware, Florida, Georgia, Kentucky, Louisiana, Maryland, Mississippi, Missouri, North Carolina, South Carolina, Tennessee, Texas, Virginia, and West Virginia. The total population, 15 to 19 years of age. There were, in Alabama, for example, there were 81,558 persons in between those age groups. Black, and in Alabama, for that same age group, there were 93,035 people, 35 persons who were white. And the number enrolled in public and high school, the number enrolled in public and private high schools for Black in public schools. If I go all the way down the list under the public schools, from Alabama, Arkansas, Delaware, and Florida, all the way down to those states that I named to you, there would be 958 Black persons, total persons between the ages of 15 to 19. There would only be 958 persons between those ages attending public school. In private school, it was more. It was 2,148 persons out of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 states. In public schools, age groups 15 to 19 for Black people, there were just 958 persons. For white people, there were 2,140. In private school, there were 2,148 Blacks. For whites in public schools between those age groups, 15 to 19, from those 15 to 16 states that I just named off, there were 27,000 persons attending high school in 1890, as opposed to nine in public schools, as opposed to 958 for blacks, and 41,000 in private schools for whites, as opposed to 2,148 for blacks. The point being is that I think if we show this chart to some of our black students in high school, it would give them a higher appreciation for high school, because they would be able to clearly see that being able to go to high school is a privilege. Okay. Uh, Back then, it might have even been a luxury for high schoolers, perhaps for black kids more so than white kids. And I guess we all can pretty much surmise that if there were only 958 black students between the ages of 15 and 19 in public schools uh, during 1890, and 2,148, I guess we can surmise what they were doing if they weren't in school. Back then, those states were still heavily agricultural. They were probably out there in the fields or on the farms doing some type of farm work or some type of agrarian labor. I would almost bet that probably 90% of them were doing that type of work. And so uh, we want to just make sure that our high schools understand that it is a privilege, it is a blessing to be able to go to school and learn. Nowadays, when other people didn't have that opportunity and probably wished so much while they were out sweating and toiling in the sun, trying to provide for their families and so forth. So, without more, that is the end of my. That's going to be the end of my session this evening. I will post this the link to this show tomorrow, as always, on the website we-grow.net for those who didn't get a chance to attend. And everybody have a joyous, nutritious, and tasty and safe Thanksgiving 2017. God bless you. Glad those who could attend could join me. Thank you. Bye bye.